State of Ohio versus Robert Keegan. Mr. Keegan is before the court with his counsel, Mr. Clark. Ms. Nicholson, on behalf of the State of Ohio, we're here for sentencing. Ms. Nicholson, anything on behalf of the state?
Your Honor, at this time we're asking that the court sentence Mr. Keegan to prison. The court is well aware of his history. I believe he's had at least 5 prison sentences. I'm not sure he's ever successfully completed any supervision. He's had multiple cases before this court, and he was purportedly in treatment at the time that this possession occurred in June of last year. He has 49 days of jail time credit, and we are requesting a $250 reimbursement to the Lebanon Police Department.
Anything from probation? Mr. Clark?
Your Honor, my understanding is the primary recommendation was what the state already advised the court. However, I believe there was a secondary recommendation, an alternate option, which would be more treatment focused. It's clear that he needs rehabilitation. I understand the court may not want to exhaust those types of resources, but those resources are designed to help people like Mr. Keegan. He does need treatment, and even if that's inpatient treatment or something to assure the court that he won't abscond, I think he needs that, and I think he's willing to take it seriously this time, Your Honor.
I definitely feel that, treatment is something that I could benefit from. There was a point in time that I probably would never even ask for it, but I think I'm close to turning the corner and potentially staying sober. And I think I could do probation, or I wouldn't even ask for the opportunity.
Your Honor, just a few other things. I did want to note that the defendant's girlfriend and mother are in the back of the courtroom as well in support of him. And wasn't there an issue of you taking methadone and not having that available while in prison? And I want to discuss that.
No, just not prison. The CBCF wasn't excited. There's no CBCF.
Okay. And how long have you been on that?
18 months.
Okay. Nothing further.
I didn't catch what all of that covers.
He's been on methadone for several, over a year.
It didn't prevent him from using heroin here. That's not good. If you're on a medication that's trying to prevent you from using, and you're still using, Narcan's been used on you how many times? That's a question.
Several.
You don't even have a number?
5, 10 maybe.
5 or 10 times you've overdosed and Narcan was needed to revive you? You say you can't do a CBCF because why?
No, they don't accept methadone.
I don't know what the methadone's doing for you because you're still using.
I think it's... last year I was clean for several months. It was an improvement and a big step in the right direction, I feel like, compared to what I've done in the past when I've got out.
2008, burglary and theft. Ended up in prison. I'm just going to hit the highlights. It's 2009, trafficking in heroin, trafficking in marijuana. 2012, possession of heroin, possession of cocaine. 2014, possession of heroin. I'll skip the misdemeanor assaults and OVIs and otherwise low-level offenses. 2018, possession of drugs, felony. 2018, in front of me, possession of heroin. 2018, again in front of me, possession of fentanyl. 2020, in front of me, possession of LSD. 2022, in front of me, aggravated possession of drugs, methamphetamines. 2022, Montgomery County, felony OVI. You're currently on active probation in Miamisburg, and it's my understanding that you had a 2025 Montgomery County case dismissed using the Good Samaritan law. Mr. Keegan, I have no doubt in my mind that you need serious drug help, and it's been offered to you. You apparently are implying that you don't want to do a CBCF because this Suboxone is so important to you. It's not working. But I'm not going to take a chance. You are, until you get to the point where you seriously want help and want to end this lifestyle, I can throw all the treatment at you I want, and it's not going to work. So with all of that, the court is going to find today that you are not amenable to community control. Prison is necessary to fulfill the purposes and principles of sentencing. Unfortunately for you, it's mostly punishment. But I have no doubt that you need help, but I don't know what else I can do to get you to understand that this is going to kill you one day. To be Narcan that many times, to be brought back that many times, to me would be shocking enough that should shock you into, I don't know. I'm going to order you to serve 10 months in prison. You have 49 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control. Upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. I do wish you luck, and I hope you make some changes in the future. So seriously. Anything else, Ms. Nicholson?
No, Your Honor, thank you.
Nothing further, Your Honor.
All right, thank you.
Mr. Counselor?
The matter before the court was the state of Ohio versus Robert Keegan, who appeared for sentencing alongside his defense counsel, Mr. Clark, with Ms. Nicholson appearing on behalf of the state of Ohio. The hearing was a sentencing proceeding, and the judge was already well acquainted with the defendants' history given the number of times Keegan had appeared before the same court over the years. Miss Nicholson addressed the court first on behalf of the state. She asked that the court sentence Mr. Keegan to prison, pointing to his extensive criminal history and noting that she believed he had received at least 5 prior prison sentences. She also noted that as far as she was aware, he had never successfully completed any period of supervision. She reminded the court that he had appeared before it on multiple prior occasions and that at the very time the current possession offense occurred, in June of the prior year, he had reportedly been in treatment. She noted there were 49 days of jail time credit to be applied and requested, a $250 reimbursement to the Lebanon Police Department. The court then asked whether probation had anything to add, and Mr. Clark, defense counsel, addressed the court. He acknowledged that the primary recommendation from probation aligned with what the state had already presented, but noted that there was also a secondary recommendation that offered a more treatment-focused alternative. He argued that it was clear Keegan needed rehabilitation, and while he understood the court might not want to exhaust those types of resources, he pointed out that such resources existed precisely for people in situations like Keegan's. He said his client needed treatment, whether inpatient or some structured form that would give the court confidence he would not abscond, and that he believed Keegan was willing to take it seriously this time. Keegan then spoke briefly on his own behalf. He told the court that treatment was something he could genuinely benefit from and acknowledged that there had been a time in his life when he would never have asked for it. He said he felt he was close to turning a corner and potentially achieving sobriety and expressed confidence that he could handle probation. He said he would not even be asking for the opportunity if he did not believe he could follow through this time. Defense counsel also noted, for the record, that Keegan's girlfriend and mother were present in the back of the courtroom in support of him. Counsel then raised an issue relating to methadone, specifically that Keegan was on a methadone program and that certain community-based correctional facilities did not accept individuals on methadone as part of their intake requirements, which was limiting the treatment options available to him. The judge addressed this directly and without much patience. She noted that Keegan had been on methadone for over a year, and yet it had not prevented him from using heroin. She described this as not good, pointing out that methadone is a medication specifically designed to reduce the urge to use opioids, and that continuing to use heroin while on that medication raised serious questions about what the methadone was actually doing for him. The judge then asked how many times Narcan had been used on him to reverse overdoses. Keegan was unable to give a precise number, saying it had been several times. When pressed further, he estimated perhaps 5 or 10 times. The judge reflected on this with visible concern, noting that being revived from an overdose 5 or 10 times was something that she would have expected to be so shocking to a person that it would drive immediate and lasting change. She found it deeply troubling that it had not had that effect on Keegan. The judge confirmed that the CBCF, a community-based correctional facility, was not an available option because those facilities do not accept individuals on methadone. She reiterated her skepticism about what the methadone program was accomplishing, given that Keegan had still been using heroin while enrolled in it. Keegan offered some context, telling the court that there had been a period of several months the previous year when he had been clean, and that he viewed this as an improvement and a meaningful step in the right direction. He compared his current situation to his past behavior, saying he felt he had made progress compared to how things had gone when he was released on prior offenses. The judge then went through Keegan's criminal history in considerable detail. She noted a 2008 case involving burglary and theft that resulted in a prison sentence. In 2009, he faced charges of trafficking in heroin and trafficking in marijuana. In 2012, there were convictions for possession of heroin and possession of cocaine. In 2014, another possession of heroin case. The judge skipped over various lower-level offenses, including misdemeanor assaults and OVIs, focusing on the more serious felony matters. In 2018, there were 3 separate cases before the same judge: a felony drug possession case, a possession of heroin case, and a possession of fentanyl case. In 2020, also before the same judge, there was a possession of LSD case. In 2022, again before the same court, he was convicted of aggravated possession of drugs involving methamphetamines. Also in 2022, there was a felony OVI case out of Montgomery County. The judge noted that at the time of the current hearing, Keegan was on active probation in Miamisburg, and that a 2025 Montgomery County case had been dismissed through the application of the Good Samaritan law. Having laid out this history, the judge stated directly that she had no doubt that Keegan needed serious drug help, and that help had been offered to him repeatedly over the years. However, she expressed frustration at the situation with the methadone, noting that Keegan appeared to be suggesting he did not want to go to a CBCF because his Suboxone or methadone treatment was important to him, while at the same time that treatment was clearly not working given his continued drug use. She acknowledged that she could order as much treatment as she wanted, but made clear that until Keegan reached a point where he genuinely and seriously wanted help and wanted to end the lifestyle he had been living, no amount of treatment would produce lasting change. She said the readiness had to come from him, and she did not yet see that. On the basis of all of this, the court found that Keegan was not amenable to community control and that prison was necessary to fulfill the purposes and principles of sentencing. The judge acknowledged that in this particular case, the sentence was mostly punitive in nature rather than rehabilitative, but said she did not know what else she could do to make him understand that the path he was on was going to kill him. She returned to the issue of the Narcan reversals, telling him that most people would be profoundly shaken by a single overdose serious enough to require Narcan, and that surviving 5 to 10 such events without fundamentally changing course was something she found deeply difficult to comprehend. The court sentenced Robert Keegan to 10 months in prison, with 49 days of jail time credit to be applied. The court found that he was indigent for the purposes of any fines, costs, or other financial sanctions, and accordingly did not impose those. The judge also informed him that he would be subject to a discretionary period of post-release control upon his release from prison, under which the adult parole authority could supervise him for up to 2 years. She explained the consequences of violating that supervision, telling him that a violation could result in being returned to prison for up to 1/2 of the original sentence imposed by the court. If the violation involved committing a new felony, he could be returned to prison for 1 year or the amount of time remaining on his post-release control period, whichever was longer, and that any such time would run consecutively to any additional prison sentence he might receive for the new offense. The judge closed the sentencing with a personal note, telling Keegan that she genuinely wished him luck and hoped that he would find a way to make real changes in his life going forward. She expressed that hope sincerely, even as she acknowledged the long and difficult history that had brought him before her yet again. Miss Nicholson indicated she had nothing further to add on behalf of the state, and the hearing was concluded.